The final case on our docket this morning is 23-30047, Llagas versus Sealift Holdings.
Your Honor, this case is not about Sealift's. This case is about Sealift's use of foreign labor on board its U.S. flagged vessels in violation of the parameters of Title 46 of the U.S. Code. And the district court's enforcement of the arbitration award violates explicit and well-defined U.S. public policy because it prevents the legitimate interest of the United States in the manning of its own U.S. flagged vessels from being addressed because it applied Philippine law in place of U.S. law, and it exempts Sealift from compliance with Title 46's manning provisions when it comes to Filipino labor. It's not about the Philippines or a POEA employment contract. And to that argument, this case should never have been compelled to arbitration in the first instance, as there was no basis to do so. Our first argument is that the district court abused its discretion in compelling Mr. Llagas to arbitrate his claim in the first instance.
The argument, as I understand it, is at least one of the claims is that under the contract, that the wages agreed to in the contract were not paid. Is that true?
No, Your Honor. That's not true. Our complaint was not drafted as clearly as it could have been. And when the magistrate judge issued the recommendation that arbitration be compelled, part of her reasoning was that we had made claims for unpaid wages under the terms of the contract. And when we saw that, we went, oh, no, that's not what we meant. What we meant is the way you calculate damages under 11107 of Title 46 is you look at the wage rate. It's a remedy. All of the wages. So what we did was we couldn't amend at that point because it had already been recommended to be compelled to arbitration. So we filed a stipulation. And the stipulation said, all wages that were due under the contract have been paid. All terms of the contract were paid. Our claims don't rely on the terms of the contract at all. And it just didn't help us very much. So, Your Honor, I'm sorry, did I interrupt? Oh, I'm sorry. So the district court compelled arbitration on the first prong of Grigson. That's the case in the Fifth Circuit for equitable estoppel, stating plaintiff's claims in this case rely on the terms of the written agreement, the employment contract, because each of his claims makes reference to or presumes the existence of the written agreement and thus arise out of and relate directly to the written agreement. But, Your Honor, we contend that that's a misapplication of the law. Right after Grigson, there were two cases that came out in the Fifth Circuit that further kind of defined what it meant to rely on the terms of a contract. And that was the Hill versus GE Power case and Palmer Ventures versus Deutsche Bank. And what they said is basically the terms of for a case to rely on the terms of the contract, the terms must be part of the plaintiff's clause of action. In other words, the duties that are alleged breach must be imposed by the agreement. And, Your Honor, the duties alleged breached by Sealift, that we're alleging Sealift breached, are imposed by Title 46 of the U.S. Code alone, not the employment contract.
What specifically are those duties so that I can in my mind sort of say, okay, yeah, that doesn't.
Yes, Judge. Title 46 imposes the manning obligations on Sealift as the owner of U.S. flagged vessels to hire merchant mariners who must be U.S. citizens or seamen. In other words, you can't hire, Title 46, Congress says, you can't use foreign seamen as foreigners as seamen.
That's what you say comes out of Title 46, and that doesn't have anything to do with the employment contract.
No, Your Honor. No, that has nothing to do with the employment contract.
All right.
That duty arises strictly from Title 46. the Philippines wouldn't have an employment contract that said, you can't hire people on your vessels as seamen. You know, if you look at it that way. The second one is that there are some exceptions in Title 46 where you can use foreign labor, but they're very limited. These are people that you can use them as a riding gang member. They're basically people that aren't seamen, but they do like repairs for the ship, welding and all that kind of thing. You can use that kind of labor, but only for limited periods of time. And that's Section 8106. And there's also a duty that's provided, that's imposed on U.S. flagship owners, that they have to provide shipping articles to people that work on board their vessels. And
Suppose we agreed with you on that point. Isn't there an alternative ground, though, on which the district court could have based its decision?
oh, the misconduct prong?
That there's intertwined misconduct with a signatory and a non-signatory?
No, Your Honor. Well, for one thing, did I interrupt you?
No,
I'm sorry. No, for one thing, that was argued in the district court by Sealift, and the district court did not find that. Now, they didn't say we don't find it.
Just didn't reach it.
But they didn't reach it. They just relied, and we're going to say that's a tacit recognition that it just doesn't apply in this case.
Well, I don't know if the district court didn't say anything. Would it be an alternative ground on which we could, I assume you would disagree that it would be an alternative ground on which we could base an affirmance. Tell me
you
why.
could if it applied, but it doesn't.
Why doesn't it apply?
Okay. Because for one thing, we made no allegations of misconduct by Lots or Magsaysay at all. As we stipulated, all the terms of their employment contract were completely met. And number two, Lots and Magsaysay are not even subject to Title 46. They can't violate it. They're not the owners of U.S. flag vessels. We would never have survived a no cause of action. We can't in good faith say that Lots and Magsaysay violate Title 46. So no, Your Honor, there are no other grounds to have enforced arbitration in this case. Now, I do want to make one thing before I move on, is that Sealift and the district court kind of latched on to one of the things that we said in our stipulation. We said, but that our claims don't rely on the terms of the contract, excepting to the extent the documents signed are in violation of United States law as set forth in 46 U.S.C. 11107. So Sealift says that by saying this, we're confirming that our claims do rely on the terms of the contract.
Did you allege that Magsaysay was a single business enterprise?
Oh, no, Your Honor. No, we did not. We've never alleged that. That was just a misunderstanding. No. What we always alleged was that the Sealift entities were a single business enterprise, not that Lots, Magsaysay, and Sealift were any kind of a single business enterprise. No, Your Honor. So what I was saying about that statement about accepting to the extent the documents, that is just, that's not us admitting or anything that the claims rely. We're just saying that the documents on their face are one more piece of evidence that Sealift was in violation of these statutes, because if you look on the face of the contract, he's obviously a foreign citizen. He's employed on a U.S. flag vessel. And even if he's considered a riding member, he's assigned to work more than 60 days. That's longer than they're allowed to work under 8106 if they're a riding gang member. So the contract is just a piece of evidence of an unlawful engagement. And we're going to submit, we could have tried this whole case in district court, never put that contract into evidence and never mentioned it. It's not about the contract. So, and I want to add, I have not found a single decision where a non-signatory vessel interest like Sealift was allowed to compel a signatory foreign seaman like Llagas to arbitration based on the first prong of reason alone. Not one. And if I missed it, I'm sorry, but I looked. They compel arbitration on the second prong, concerted misconduct. or some combination thereof. And that's what the Francisco court did. In Francisco, that's cited by Sealift, arbitration was compelled on the misconduct prong, and the reliance prong was found specifically not to have been met because the obligations sued on were imposed by the Jones Act and not by the terms of the POEA contract. So, Your Honor, we fought against arbitration in the Philippines so hard because, even to the point of trying to get mandamus, was because we felt the likelihood was that the Philippine NLRC arbitrator would apply Philippine law to this dispute, and that's what happened. Now, Sealift in their appellate brief does not dispute that the arbitrator applied Philippine law in its decision. Instead, Sealift argues this court's decision in Asignacion permits the application of Philippine law to U.S. flagged vessels. And to the contrary, we submit that Asignacion supports vacation of the court's order enforcing the award. Asignacion recognized the U.S. Supreme Court's statement in Richman versus Larson that a choice of law clause that applies foreign law to a U.S. flagged vessel was against U.S. policy. Now, in these cases, that was dicta, but this is the dicta case. In this case is not Richman. This case is not Asignacion. In Asignacion, the vessel was flagged in the Marshall Islands and owned by German interest. Here, the vessel is flagged in the United States, and of course, U.S. statutory laws are at issue. Moreover, in Asignacion, the issue was the money remedies available under Philippine law and whether those were in violation of the U.S. public policy of solicitude towards seamen. Your Honor, the policy here isn't the remedy of a Philippine citizen. This is not a personal injury case. The issue here is the interest of the United States in regulating the manning of vessels that fly its flag. Also, the Asignacion court determined effective vindication was not an issue because the doctrine only applied to statutory rights and there were no statutory rights. Oops, oh no, I'm okay. Okay, excuse me. Okay, so to get out of this Asignacion-Richman analysis, Sealift actually is trying to get out of Richman by saying the arbitrator used Richman analysis, but he didn't. He did never mention the word Richman. He never considered any of the claims of Richman except for it was a Filipino and that the contract was in the Philippines. Oh, in fact, the fact that he used the term, the contract's choice of law is evidenced by the fact that he said if he wanted the benefits of U.S. law, he should have added it to his POEA government-approved contract. So in other words, he said if he wanted U.S. law, he should have put it in the contract. So he definitely used the contract's choice of forum clause. The other thing is that Llagas was wholly unable to vindicate his U.S. statutory rights in the Philippine Arbitral Forum. Effective vindication under Mitsubishi requires first that the arbitral tribunal should be bound to decide the dispute in accord with the national law giving rise to the claim. Arbitrator missed the first step entirely. Then the enforcing court is supposed to look to see whether they actually took cognizance of the statutory claims and actually decided them. And Your Honor, he didn't after the arbitrator already decided the case under Philippine law. And then he made a 2-sentence ex gratia argumenti conclusory statement that we miserably failed to prove our claims. Your Honor, it was made ex gratia argumenti. That means it's not a legal decision on the merits. Also, if you want to, it doesn't even meet the requirements of the NLRC itself for a decision that they require. They're arbitrators. For it to be a decision on the merits, there are certain elements, and all that's in our brief. So, Your Honor, I'm going to conclude with enforcing the award renders Section 11107 unable to serve its remedial and deterrent functions, Sealift is able to continue to violate Title 46 in the manning of its U.S. flagged vessels. And the order enforcing the award should be vacated as against U.S. public policy. And also the order of the court compelling arbitration in the first instance should be reversed and this matter sent back to the district court. Thank you very much.
Your Honors, Alan Davis on behalf of the Sealift entities. In preparing for this morning, I noted that in the reply brief, there was some criticism that we didn't phrase the issues presented on appeal the same way that they did. So I want to address the issues as they framed them on appeal very directly so there's no confusion. The court absolutely ordered arbitration correctly, did not abuse its discretion in doing so because the claims brought by Mr. Llagas rely on the terms of his contract. They presume the existence of the contract. Those are the standards under Grigson. That decision was made by the magistrate judge twice, once after reconsideration, and by the district judge twice, once after reconsideration. So that's the first element or issue they've raised. The second issue is that the arbitrator properly took cognizance of and actually decided Mr. Llagas' claims under U.S. law. The complaint that they've asserted against that is that they say, well, he didn't spend enough time actually on the merits of the U.S. law claims. He spent a lot of time, they point this out, on the choice of law issue of what law governs these claims. He spent several pages on it, and he didn't, it's correct, he didn't cite Lauritsen because he didn't cite any U.S. authorities, but he looked at the place that the contract was performed, the place that the parties were from, the flag of the vessel, the place that the contract was entered. He looked at all of the, I believe Lauritsen and Rhoditis together have 7 factors. He looked at all 7 of the factors with the exception of one, which is the interests of the foreign forum. And he didn't look at that one. It makes sense because he was the foreign forum. So his interests had already been acknowledged. So there's absolutely no basis to challenge the decisions of the arbitrator. And frankly, there's no authority in law for courts here to go behind the arbitration and sort of reanalyze the issues.
Counsel opposite argued with respect to the first Grigson basis that there was a misunderstanding that their claims did not actually rely on the employment contract, but instead were relying on manning obligations under Title 46. What's your response to that?
So a couple of things. First of all, the district court can only look at the claims that are presented in the petition. And I think there was an admission or an acknowledgement during the prior argument that there were wage claims absolutely presented. They were actually presented as a class action claim. And it said one of the issues that will predominate the class action is the failure of Sealift to pay wages and overtime that were earned under the contracts. Those claims are still in the petition. The petition was never amended. There was never a dismissal of those claims. There was a stipulation, perhaps, that we're probably not going to have any evidence for those claims, but they were never removed. And I'll also add, when the petition was filed with the Filipino arbiter, those claims appear in the petition filed to the Filipino arbitration as well. They essentially copied the petition that they say had gotten them in trouble in the district court and filed the exact same claim. So those courts have to look at the claims before. As to the specific, the claims absolutely refer or rely on the terms of the contract. As it was just said, the basis of the claim is that he was employed on a U.S. flag vessel and shouldn't have been. It's the contract that assigned him to a U.S. flag vessel. It's that he was employed for more days on a U.S. flag vessel than he should have been. It's the contract that determined the number of days. He alleges in his petition that he performed all of the duties assigned to him. It's the contract that assigned those duties. He makes allegations about his seaman status. It's the contract that you look at to find that. Everything that he's alleged, I could go on, he's got his claim under Section 10302 that there were no articles of Seaman's articles signed. The contract is equivalent to the Seaman's articles under Filipino practice and law. So all of these things that he's saying were violations, he's saying that the contract is the violation.
Well, it seems like it would be pretty superficial to have United States laws that said if you employ a foreign seaman, at a minimum you must pay X, and they can't work beyond X, and the for the owner of a vessel to say, well, it's all in the contract he had with this foreign country, his homeland, so me no Alamo, I don't have to worry about it. I mean, that surely,
Well, it's not the employer that's saying, for one, there is no claim in this case that he was underpaid. There's no claim that he has any injury, either a physical injury or a monetary injury. There's no claim that he was mistreated. There's no claim.
I thought the claim was that the contract wages were below the statutory minimum.
The claim is that it's not exactly that. The claim is that there's a statute that says in the U.S. if you employ a seaman contrary to the laws of the U.S., the contract is void, and he's entitled to either the amount that he was agreed to be paid or the highest rate of pay in the port of engagement. The entire strategy or theory behind this case is that they're attempting to void the contracts of a Filipino worker and say that because his contract is void, he's now entitled to the same rate of pay from the port of engagement, which they contend is somewhere in the U.S., although he has never been to the U.S. as far as the record shows. They want him to be paid the same rates that U.S. union workers are paid. There is ample authority that is not an appropriate remedy. There's a sister case that's cited in the briefs that's been pending in New York for about 21 years on virtually identical claims, where the judges said that as to all of the Filipinos, you're not to be treated as U.S. union workers. That is not the appropriate damage, if there were any damage, which we don't believe there are. So I don't think that's exactly his claim. But beyond that, to the extent that is his claim, that claim was decided in arbitration. And the arbiter found that there was not evidence presented to support the claim. And the Mitsubishi decision in particular, Asignacion, which we think is very strong authority for us, are very, very clear. You do not second guess an arbitrator's decision, especially in the context of international commerce.
Well, there are two issues. One, should it ever been sent to arbitration versus the validity of the award? Those are very different things. But.
Correct. And that's going to the second issue. Yes, Judge. On that issue, I will say that I still, at this point, and this is the third issue on appeal that they presented, they have not identified any public policy that they claim is violated by the arbiter's decision. And it's not just any public policy that they would have to identify. Asignacion says that it must be an explicit public policy that is well-defined and dominant. General considerations of supposed public interests are not enough. But in this court's decision in Botus 2 in 2004, the public policy defense is to be construed narrowly, to be applied only where enforcement would violate the forum state's most basic notions of morality and justice. There are plenty of cases, several cases, I should say, in the briefing where the Asignacion is an example, where this court said that, okay, the Filipino arbiter did not provide maintenance and cure benefits to a Filipino worker in a Filipino arbitration, meaning his recoupment, his medical expenses for an injury, in some cases a very serious injury, permanent injuries, were not paid. And in Asignacion, this court said that doesn't rise to the level of a public policy concern that we're going to say overrides a foreign arbitrator's decision. I submit that if the recoupment of seafarers who are not given their maintenance and cure benefits through a Filipino arbitration does not rise to the level where we refuse to enforce a foreign award, certainly the claims in this case do not. There were some other statements during the opening, the prior argument that I'm happy to respond to. I'm happy to answer any questions. If there are none, I'm also happy to rely on the briefs. I know it's been a long day.
Thank you, counsel.
Thank you.
Your Honor, just briefly. Your Honor, there was never a claim for unpaid wages under the terms of the POEA contract. And we could not amend our claim to make that clear once it was, once the compelling arbitration was set in motion. So that's why we did the stipulation. And we have never maintained that there's any unpaid wages under the contract. The district judge recognized that that's what we were saying in the stipulation, and he remanded it back to the magistrate judge for reconsideration. But it just didn't change the result. But the district court recognized that we had removed the issue of contractually due wages from our claims as best we could, given the procedural state that it was in. Let's see. Oh, the argument that we made claims for unpaid wages in the NLRC is incorrect to the extent we did. That's because the NLRC form, it's a complaint form. It's basically a workers' compensation court. There's not a place you can put these claims on that form. And that's why we had to list it's basically a box check form, and we had to list what we could. But that was clarified in our position paper. And we had our Philippine counsel put, it's not an affidavit, it's in the record that said that that's allowed by the procedural rules of the NLRC, and he made it very clear. We're not suing for any unpaid wages. We are only bringing claims against Sealift for violations of Title 46. So no, there were no contractual wages on the table in here or in the Philippines. Your Honor, I can't. The bottom line is that we just want Sealift to abide by Title 46 and the requirements of Title 46, because that's what Congress has said. If you want the privilege of flying a U.S. flagship, you have to abide by the obligations imposed. And I don't know of any stronger public policy than Congress.
Well, when Judge Hicks remanded it to the magistrate after you filed your stipulation, did you raise that claim with the magistrate judge and then again with Judge Hicks?
I'm sorry, raise what claim?
What you just said, that all you want is for Title 46 to be enforced. Is that did you make clear to the magistrate judge that's all you wanted?
Yes, I believe that was clear all through our statements that our claims didn't rely on the contract, that they relied solely on violations.
And the magistrate judge and Judge Hicks ruled what with respect to that claim?
That was part of our claim, that our claims relied on the terms of the contract. They just said, no, they don't. They said, you said in your stipulation that, I'm sorry, what's the language? You said in your stipulation that your claims don't rely on the terms of the contract, except to the extent that the terms of the contract or the contract itself is in violation of Title 46. But like I said, we were just showing that was like a piece of evidence that the engagement was in violation of Title 46. They used a but-for analysis. In other words, I think that's what I'm trying to answer. I think they used a but-for analysis. In other words, but for the fact that he had an employment contract, he wouldn't have been on Sealift's vessels. So therefore, it relies on the terms of the contract. In fact, the magistrate judge in her first initially said the claims rely on the contract. So, well, that's not what it is. It has to rely on the terms of the contract. So then we asked for reconsideration, and it was granted so that the language was changed. The claims rely on the terms of the contract, but no result. The result didn't change for us. So, Your Honor, with that, I conclude. Sir. Okay, thank you.
Thank you, counsel.
Thank you.
That concludes the arguments for this morning. The court will reconvene at 9 o'clock in the morning. Thank you.